We at Welfare Rights Centre acknowledge the traditional owners of the land on which we are today, the Gadigal of the Eora Nation, and pay our respects to elders past and present. We respect that this land always was and always will be Aboriginal land. So Welfare Rights Centre is a community legal centre specialising in social security and family assistance law. We provide information, referrals, and legal representation to thousands of people in New South Wales each year who have a problem with Centrelink. Our peak organisations are Community Legal Centres New South Wales and Economic Justice Australia, who we work with to advocate for law reform. So the aim of today's session. There's a lot of complex information in the session, but we're hoping that you will get a basic understanding of the structure of Centrelink payments for people with children, be alerted to common problems experienced by people receiving payments while caring for children, understanding how to appeal against a Centrelink decision, and we'd like for you to be able to refer to Welfare Rights Centre for legal advice and so that we can provide ongoing support. Today's presentation is general information only. It is not legal advice. Clients should obtain legal advice about their individual circumstances. So just to reiterate, please keep the questions broad in the chat. We cannot give out legal advice today. Okay, so now we're going to launch a poll. The question is, what kind of issues are you seeing? So it's understanding how the system works, what payments are available, understanding the rules for each payment, problems with paid parental leave, problems with childcare subsidy, problems trying to balance mutual obligations with care of kids, family tax benefit issues linked to disputed care arrangements or erratic child support payments, family tax benefit issues estimating or declaring income, and accessing payments for a child with disability. Majority of people answered that they are having difficulty understanding how the system works and what payments are available and understanding the rules for each payment. So hopefully we'll be able to bring a little bit of clarity to both those things. I'll now hand it over to Natalie.
Thanks, Bree, and hello, everybody. As Bree said, the session today has a lot of complex information about quite a wide range of payments. The Social Security Act is massive, well over 1,000 sections, plus hundreds of pages in the publicly accessible policy guides, plus more hundreds of pages in the blueprints used internally by Centrelink staff. So it is enormously complicated when you get down to the technicalities of it. It takes us about a year to train a new lawyer to have a basic understanding of Social Security law. So we'll go through at a reasonably basic level some of the key payments for families with children and some of the problems that we see here at the Welfare Rights Centre in our day-to-day work. And we hope that will be helpful for you. So obviously we have many hundreds of thousands of people in New South Wales getting Centrelink payments. The most obvious ones for children, for people who have children, is the family tax benefit and parenting payment. But of course there are many others, and parents may be getting carer payment if they have a child with a disability. They may be getting special benefit if they're not able to get any other kinds of payments. We occasionally have a parent who's on the age pension, or maybe a parent who's a student on a student payment. So there are many payments that parents might be on, but we'll focus on the main ones to do with caring for children. Because it's an enormous system, mistakes do get made. And so we do encourage our clients and those people who advocate for them not to necessarily just accept a Centrelink decision, because there's certainly a chance it may not be correct and can be worth challenging. We find our clients take it very personally when decisions are made that affect them, or if they feel accused in some way of doing the wrong thing. And it doesn't, I suppose, really help them to know that this happens to so many other people as well, struggling with the Centrelink system and having decisions made that have bad effects on their lives. So we're going to start by talking about some of the general issues across Centrelink payments that can cause problems for people, but relatively briefly, given the limited time we have available today. So the first key one is about Australian residence, which is a criteria for almost all payments that the person applying for the payment is a permanent resident of Australia. There are a few exceptions relating to special benefit, paid parental leave, and family tax benefit for temporary spouse visas, humanitarian visas, and some for New Zealand citizens. But by and large, if a person's not a permanent resident of Australia, they are unlikely to be eligible to get any kind of income support payment from Centrelink. If that person has children who are Australian permanent residents or citizens, there may be some options for them, and we'll talk about that situation later in the presentation. You also generally need to be in Australia when you put in your application. For some people, whether they're a resident of Australia or some other country can be in question if they're a person who moves between countries frequently or has homes and families in more than one country. And sometimes that decision about whether a person is a resident of Australia or not has to be made first before a person can get any further. We also have rules that apply to new migrants to Australia. They're relatively harsh rules that mean that people have to wait commonly 4 years for most income support payments to be able to get a payment at all. There are some limited exceptions to that 4-year waiting period, which apply to refugees and family members of refugees, and a couple of exceptions for particular payments. But most new migrants can expect to have to wait a long time before they can get a Centrelink payment. What is good to know when you're dealing with families is that if a person becomes a single parent after they become a permanent resident in Australia, there is an exception that can allow them to get parenting payment. So it's good to look into if any of the exceptions to these waiting periods apply to your client. Some of the other issues that come up that are across all Centrelink payments but can particularly affect families and people with children is the issue of whether a person is a member of a couple, because this affects often whether a person can get a payment at all and also the rate of payment, because you're probably aware that for most Centrelink income support payments, the rate paid to a single person is higher than the payment that a person will get if they're a member of a couple, with an idea that members of a couple can pool resources and have lower living expenses. I think it's the kind of policy rationale behind that. So while for most people, whether you're a member of a couple or not, is pretty straightforward, I'm sure many of you have experiences with clients who that is not a straightforward answer. People with on and off again relationships, people in violent and abusive relationships. And in terms of how Centrelink makes that decision about whether a person is a member of a couple or not, the Social Security law sets out the 5 factors there on the slide: the financial aspects, the nature of the household. The social aspects means how you present to the community. Do your family and friends know you to be a single person or in a couple? Whether there's a sexual relationship, of which you'll be pleased to know only limited inquiries are made, but the birth of children is often connected to that factor. And the nature of people's commitment is about who you rely on for support and who you would turn to in an emergency. So this is something that comes up persistently for our clients. Now, Centrelink will recognise that a person can be separated while living in the same premises as their former partner. But we also find that they may not accept that separation under the one roof over the long term. So we've got a case study here, which is a pretty common situation for clients we see. So in this situation, our client did separate, but for financial reasons remained living in the same house with the ex-partner. But, they lived in separate rooms. They went about their lives separately. Our client wasn't working. Her children were still young. So she was getting parenting payments, single and family tax benefit. She was using that money to care for the children. Instead of getting child support from her ex-partner, the rent that he was paying was recognised in lieu of child support. So they were managing their separation that way. But some years later, Centrelink made a decision that she'd been a member of a couple the whole way along since the date she'd told them she'd separated. And she was asked to repay the parenting payment single she'd received because they said, well, you weren't single, so you're not eligible for the parenting payment, single rate payments. And she was asked to repay family tax benefit payments because since they considered her a member of a couple with her ex-partner, his income was taken into account in the rate of family tax benefit payments they said she was entitled to get in that time. So what we find is while Centrelink will usually accept that a couple is separated under the one roof in the period of a few years after separation, and I suppose recognizing that it can take quite a long time to get back on your feet, separate your finances, go through a property settlement, whatever it might be. But if for whatever reason, and they're usually economic, people remain separated under the same roof through a number of years, we do find it's common for Centrelink to decide, well, it looks like you weren't really separated after all, and we'll change our decision to accept that you're now a single person. Now, in terms of moving on to look at particular payments that are available to families with children, I'm going to start with paid parental leave, but we won't spend a lot of time on this. I noticed from the poll at the beginning, this is not something that seems to come up for people very often. So paid parental leave has had some changes in the last few years, which have made the scheme a bit more generous and over time extended the number of days that people can get paid parental leave payments for, and also made it a bit more flexible between the two parents of a child. So basically, you need to have a newborn or newly adopted child. It's the primary carer of the child who's not working for more than an hour in a day who's eligible to get those payments. You obviously have to be the Australian, meet the residence criteria. You have to meet income tests, and you also have to meet the work test. The work test says that you have to have worked in 10 of the 13 months before the child was born or adopted, and you have to have worked a minimum number of hours in that 10-month period, which works out roughly at a day a week. And you can't have a gap of more than 12 weeks between work days. So it's a pretty complicated test. Work means a bit more than just like me sitting here at my desk now. Work days include days you're on paid leave, days you're not working but are receiving workers' compensation payments. If you're not at work because you're on jury service. Also, if you're not at work because you're on paid parental leave days for an earlier child. And it also covers people who are self-employed as well. There are some exceptions to that length of time you have to have worked. If you've got pregnancy-related illnesses or complications or premature birth. And there's also some exceptions for special circumstances like domestic violence, natural disaster, things that disrupt people's lives significantly. In terms of what people get, people are paid the national minimum wage. And at the moment, people can get 110 days of paid parental leave. If a person is a member of a couple, one member of the couple, 10 days of that has to be reserved for at least 10 days has to be taken by one member of a couple and the balance by the other. So the common situation is the birth mother might take a period of paid parental leave, and then the rest of the days can be taken by the birth mother's partner after the birth mother returns to work, for example, is a common way of doing it. But if the birth mother is single, she can have the whole 110 days to herself. There's a time limit within 2 years of birth or adoption for using those paid parental leave days. And the system is set up so that if you're still employed during that period after birth, the payments can come via the employer. But if you're not working at the time of birth, they can come directly from Centrelink. Any questions so far?
Hi, Natalie. There's a couple of questions here. Somebody asked about regarding residency.
Mhm.
How does that affect returning citizens? Do they have the same rules?
Returning residents or citizens generally need to show that they're returning on a long-term basis. So you can't kind of fly in, apply for your payment, fly out again. So that you're re-establishing your residence in Australia. There are some payments where there are some extra rules for returning residents, but they don't really relate to the payments we're talking to today.
Okay, and there are two questions regarding the first case study.
Okay.
Why would they have changed their mind on the initial decision?
They seem to say that given you haven't taken steps to separate out your lives completely, that means that the initial so-called, claimed separation wasn't genuine. I think that's the approach.
Okay, and did your client have to pay back the money, or did they have enough evidence to prove they were separated under one roof over many years?
Now, this is a good question. I don't think this was a case where we represented, so we didn't get to see what happened in the end. But we would have advised them about their right to appeal, first an internal appeal, and then to go to the tribunal if necessary to try and establish that they were genuinely separated. And they may well have succeeded in doing that. The tribunal is much more kind of flexible and open-minded probably than the Centrelink decision makers on these issues.
Okay. There's a question regarding paid parental, the parental leave payment.
Mhm.
Is there a certain amount of time prior to the birth that you can take for for parental leave payment? For example, 6 weeks before due date, 8 weeks, etc.
No, you can lodge your claim before birth, but you can only take the parental leave after the baby's born.
Okay. Uh,
We
when
might move
sent,
on, Bree, though, I
oh,
think, so
sure.
we can,
Okay,
sorry to interrupt, but I think
that's okay.
given the time, we need to keep on keeping on.
Fair enough.
All right, so the next payment I wanted to talk about was parenting payment. So parenting payment comes in two versions, partnered or single, and the criteria are different depending on whether you're partnered or single. So if you're the principal carer of a child under 6 years, you can get the parenting payment partnered, subject to what income your partner may earn and what assets your partner may have. If you're a single parent, you can get the parenting payment single if you're the principal carer of a child under 14 years. So that under 14 years was a change that came in when this current government was elected. Under the previous government, single parenting payment was only available to people whose youngest child was under 8 years. So it was increased significantly in the last few years. Now, if parents are separated, only one of them can get the parenting payment. So if the care of a child, so if it was hard to determine who is the principal carer, so if the care of that child happened to be shared precisely 50-50, then Centrelink has to make a decision if both of those parents applied for parenting payment, who they're going to determine is the principal carer and therefore the person who can get the parenting payment. That is different to family tax benefit, which, as you'll see a bit later on, can be shared between separated parents. Although it's called parenting payment, people who are not parents can get parenting payment if they're the principal carer of a child, such as a grandparent or a step-parent. It's also possible to have breaks from caring for children for up to 8 weeks and still get that payment. But it is important to recognise for that parenting payment partner that there are income and assets tests, and that apply to both the person who wants the payment and their partner. And that applies even if their partner is not the parent of those children, their income and assets are still taken into account for whether the parent of the child can get the parenting payment. So the term principal carer means the person who's responsible for the day-to-day care and development of that child. So it's very much a day-to-day care concept. The problems we see for people getting parenting payments, the member of a couple dispute is very common. And as we discussed earlier, the problems that can come up with that are where Centrelink accepted people separated under one roof, but then decide after all, no, we don't think you are genuinely separated. It can apply when people ask to be considered separated under the one roof and a decision's made that they're, again, not genuinely separated. It can come up with where people have been getting parenting payment single for many years and then Centrelink make a decision that we think after all, you haven't been single, you've been a member of a couple over a period of time. That can lead to a person arriving with a very big debt. They may have had 10 years of getting the single parenting payment and then Centrelink saying, we've looked at your Facebook pages and the names on your lease and, you know, your travel arrangements, and we've decided you've been a member of a couple all this time and you have to pay us back the parenting payment. We've mentioned the dispute about which member of a separated couple might be considered the principal carer of the children. Parenting payment has what's called a qualifying residence period of 2 years residence in Australia, as well as the newly arrived resident waiting period of 4 years. If you are a newly arrived resident, the 4 years encompasses the 2 years. So you wait 4 years, not 6, although there are those exemptions for refugees and family members of refugees and people who became single parents after becoming an Australian resident. People have to report their own and their partner's income every fortnight to get parenting payment. Sometimes if people are in violent and abusive or coercive relationships, their partner may not provide that information to them so that they can report as they're required. And it may later, come to Centrelink's attention that the partner's income was in fact higher than what was reported, and that could lead to a debt. There can also be some confusion with that fortnightly reporting of your income and your partner's income with the annual household income estimates that you have to do for family tax benefit. So they're two separate regimes and two entirely separate ways of providing information about income. And that really confuses people. So parenting payment single is higher than parenting payment partnered, like all other payments. It's another payment where you can't get parenting payment until the child is born. You can't get it ahead of time. Although if people are on job seeker payment before the birth of a child, they don't have any mutual obligations in the 6 weeks before the expected date of birth of that child, and then can get potentially parenting payment after the child is born. And then we have, like all the other payments, we have income and assets tests that determine if a person can get a payment and how much they can get. The next topic I wanted to talk about is that mutual obligations for parents. So mutual obligations are the conditions that are imposed on people receiving some parent payments from Centrelink. I suppose the idea is that if the community is giving you money, you have to do some things in return. So for people who get job seeker payment, parenting payment, or special benefit, if their youngest child has turned 6, they will likely to have some mutual obligations in terms of looking for work or doing training programs, unless they've got an exemption, and we'll talk about the exemptions. A significant exemption is that principal carer parents are not required to undertake mutual obligation activities that are outside of school hours. So it's recognised you have to pick your children up from school. Some of you may have heard of the Parents Next program, which was a mandatory program for some people getting the parenting payment with children under 6. That was abolished by the current government, and they put in a new program called Parents Pathways, started on 1st of November last year. But the difference is that this is a voluntary program. So there's no suspensions and payment suspensions, no coercion involved. People can choose to participate or not. So from our perspective, that's a big improvement. Now, we might take a closer look at those exemptions from having to look for work and undergo training for people with children. So some of these exemptions, we've talked about the one if you have basically if you have preschool age child or children, you don't have to look for work. If your children are doing homeschooling or distance education, if you have a large family, which is defined as 4 or more children under 18, if you're caring for a child with a disability, which could be long-term or temporary, if you're experiencing domestic violence, if you had a death in the family, if you're caring for someone with an adult with a disability or an aged relative, as well as your children. So there's quite a lot of situations where you're not expected to look for work and do training to improve your ability to find work. And I should have said that any of those decisions that Centrelink makes about whether you're eligible for an exemption or not, you can always challenge those decisions, and we'll talk about how you do that towards the end of the presentation today. So our next lot of payments we're looking at are about payments for those families where they have a child or children with a disability. So carer payment, which I'm sure many of you have heard of, comes in 2 versions: carer payment brackets adult and carer payment brackets child. So carer payment is an income support payment. So it's equivalent in amount to a pension. So you need to be caring for a child who's under 16, who has an illness or a disability that's likely to last for more than 6 months. Now, the illness or disability has to be relatively significant to be able to get carer payment. And to determine whether the child's illness or disability is severe enough for the parent to get carer payment, this assessment tool is used called the Disability Care Load Assessment. And in the next few slides, we'll look at a few sections of that assessment tool. There are also income and assets tests for the carer payment. And the carer payment brackets child will stop when the child turns 16. And so if that child is likely to still need care after they turn 16, then the parent will need to make a new application for carer payment brackets adult, and suggest doing that several months before the child turns 16 to have some kind of continuity in payments. And the child is going to be assessed under the adult disability assessment tool for that application, which is a different form of assessment. And so I suppose it's potentially possible that your child under 16 was assessed so that you were eligible for carer payment. It's not guaranteed that when that child's assessed under the adult tool that you'll still be eligible. Well, obviously depend on the nature of their disability or illness. Now, carer payment is a separate payment to carer allowance. So carer allowance is not an income support payment. It's not meant to give you an income because you can't work for some reason. It's a supplementary payment, an extra, an add-on. So many people who get carer payment will also get carer allowance, but people on other income support payments can also get carer allowance as well. So to get the carer allowance as a supplementary payment, it's also for children under 16 who have an illness or disability, although this time, rather than lasting at least 6 months, which is the rule for carer payment, for carer allowance, it needs to last for more than 12 months. And again, the child has to be assessed under this disability care load assessment tool. For carer allowance, there's an income test, but no assets test. So that's a slight difference with carer payment. And anyone who gets carer allowance gets a child disability assistance supplement every year without having to apply for it. It just should arrive. And like carer payment, with carer allowance, it will stop when the child turns 16. So before the child turns 16, you need to make a new application for carer allowance for an adult and have the new assessment of that child under the adult assessment tool. Just wanted to show you some of the sections from the disability care load assessment. So with these assessments, generally the caregiver fills out a section of the questionnaire and a health professional fills out another section of the questionnaire. So these are some questions from the health professionals section of the questionnaire, looking at a child's behaviour. And you can see here the questions are asking about is the child uncooperative and disruptive while being assessed by the health professional? Does the child demonstrate self-harming behaviour? Are they aggressive or violent towards people or property? Does the child abscond or attempt to abscond? Is the child hyperactive and can't concentrate for more than a very short time? Does the child have obsessional and repetitive behaviour? So you can see these are quite significant behavioural problems that are being looked for here in this disability assessment for children. This is the section about care needs. So you can, again, quite significant, whether the child receives food and drink via a tube in the stomach, whether the child needs a ventilator or oxygen therapy, whether an older child is incontinent, whether an child over 3 can stand and walk, whether the child needs a wheelchair, specialist equipment to communicate, seizures, and difficulties with memory, concentration, planning, and organisation. So again, quite significant disabilities that they're looking at in these assessment questionnaires. Now, some children for whom a parent has been getting carer payment and carer allowance may have such a significant disability that when they turn 16, they may be eligible to get a disability support pension payment themselves. It's quite a high bar to get a disability support pension. We're not going to go into that in much detail today. We've got a whole other session on disability support pension that you'll be able to attend at some time if you want to, or watch the video of. But if a parent thinks that their child has such significant disabilities that they're not likely to be able to study or work, then a claim for disability support pension can be submitted 3 months before that child turns 16 years. The next payment I wanted to talk about is special benefit. So special benefit is what we call a payment of last resort. So you're only entitled to special benefit, or not even entitled, because unlike other payments, it's a discretionary payment. So you can generally only get special benefit if it's clear you're not eligible for any other types of Centrelink income support payments. Special benefit also has a waiting period for new migrants, that 4-year newly arrived resident waiting period. But unlike other Centrelink payments, with special benefit, if the new migrant can show they've had a substantial change in circumstances since they arrived in Australia or since they became a permanent resident, they may be able to get special benefit payments before that 4-year new resident waiting period has expired. So that's certainly something to think about and to come to us and get advice about if you have a client in that situation. When I said it's a discretionary payment, the other Centrelink income support payments are legislated entitlements. So if you meet the criteria set out in the Social Security law for that type of a payment, then you're entitled to that payment. Special benefit, there's no absolute entitlement to it. It's at the discretion of the Secretary of the Department of Social Services whether you can get that payment. And so there's a lot of the application of policy around who gets special benefit and who doesn't. Now, I mentioned at the beginning, sometimes people are in Australia who are not permanent residents. They may have been here a long time. Sometimes it can be 5 years, 10 years, but they've always been on a temporary visa and they're still on a temporary visa. And their relationship may break down, or they're the victim of domestic violence, they've got a significant illness and can't work, whatever it might be. But because they are not a permanent resident, they may not be able to get any Centrelink payments. However, if they have a child who's a citizen or permanent resident, that child might be granted special benefit payments. And if there's more than one child, each of them could get a special benefit payment. So generally, if a parent's not eligible and you can show that the family's in hardship and the parent has no way of supporting that child, then special benefit might be a possibility. If the child is of an age old enough to go to school, they also need to show that they're at risk of homelessness if special benefit is not granted. So this is an area where we would encourage people to come to us for advice if a special benefit claim is rejected, because this may be, the only chance to get some kind of income support payment where a family's in hardship. If your child is over 16 years and over, and if they can't get youth allowance, they may be able to get special benefit if they're not being supported by their parents and have had a significant change in circumstances since becoming a permanent resident in Australia and are in financial hardship. So I suppose if a young person has had a breakdown in their relationship with their family, that'd be something to consider as an option. So Bree, we're up to questions.
Okay, there's been quite a few coming through.
Okay, I think we've got a bit of time now, so that's fine.
Okay. Regarding parenting payment, when Centrelink changes a decision for a single payment, does the client get paid back the full amount or the difference between partnered payment? Yeah, so I guess they were paid for a partnered payment and they changed the decision that it's a single payment, so should they get back pay?
Potentially, yes, if a decision was changed, decisions can be retrospective and backdated to an earlier time, in which case the person should get back pay. And in this case, yes, it would be the difference between the partnered rate and the single rate if they were found to be single and had been being paid as partnered.
If parents live separately but have a shared mortgage, could they still get the single parenting payment?
It's hard to be definitive in these situations. If they're living in separate premises, that makes it much more likely. But if there was ever any question about whether there is a couple relationship or not, the fact of a significant shared financial commitment, like a mortgage, would definitely be an indicator of being a couple. And it would depend on what all the other indicators showed when looking at their whole situation, whether those people would be considered to be a couple or not. It's possible to be considered a couple for people who live in separate places. So it's not impossible, but it's not as common to be considered a couple if you're living in separate places. But things like shared finances and loans and so on may lean towards being a couple.
Okay, so if both parents have 50-50 care of a child, how does Centrelink make the decision on who gets the parenting payment?
There's a section of the Social Security Guide that covers this, and I'm just trying to remember what it says, and I'm not succeeding at the moment. I think that would look at what's happening on a day-to-day basis. We might be able to find it and put it in the chat.
Yeah, I'll try to find that and put it in the chat for that person. Okay, sorry. What payments are the clients eligible for after their youngest turns 14?
All right. Well, in that case, it would depend on their situation. For most people, it will mean going on to the job seeker payment, which is a lower amount of money, and will mean they've got they would have still had mutual obligations on their parenting payment, so that would continue with their job seeker payment. So most likely job seeker, unless they happen to have a disability that was so severe they were eligible for the disability support pension, or unless they were caring for someone that meant they might be eligible for carer payment.
In
or unless
relation,
they were quite old when their child turned whatever, 14 and they were eligible for age pension at that stage, but that's probably unlikely.
Okay. In relation to the 8 weeks temporary absence, can the person who is caring for the child during this time also receive the payment?
Not usually, because usually it would just be a temporary kind of delegation of caring responsibilities rather than a handing over of care of that child. So I don't think so.
If one person is a temporary resident and the other, and the other parent is overseas, what parenting payment could the temporary resident apply for? Is there anything available?
Um, no, generally not, unless if they're on a temporary spouse visa, they might have access to special benefit. But if they're on any other kind of temporary visa, probably nothing.
Uh, for people on parenting payment who are unemployed, do they still have to report their income fortnightly?
Yes, everyone on parenting payment needs to report income unless, yeah, Centrelink is tells them not to. But yeah, generally there's the fortnightly reporting obligation is there for everyone.
Uh, what sort of evidence do you need to prove disability, temporary illness, or injury?
Is this in relation to carer payment?
I believe so, yes.
Okay.
Sorry.
Well, there is that. It's the assessment tool,
Mhm.
which is completed partly by the carer and partly by the treating health professional. So
Uh, the
that's what's
disability
used.
care load assessment. Uh,
Yes,
yep, and I did put
that's
the
the
link for
one.
that in the chat if
Ah,
anybody
thank you.
needs that.
Thanks, Bree.
Uh, do we still have time for a couple more?
Yeah,
Or?
yeah,
Yep.
we do.
Okay. Regarding Australian citizenship, does a client who is from New Zealand uh, and they have gained Australian citizenship, do they still have to wait 2 years? I believe once they're an Australian citizen, they should be fine, right?
Yes, Australian citizens are exempt from that new resident waiting period.
Okay. Um, if a child has not yet received their child disability assistance supplement, which I guess they are due, for their child, what should they do?
Mm. Contact Centrelink and ask what's happening.
Okay, yeah, I actually thought that, but I just wanted to clarify with you as you're the lawyer. Um, okay, so if one parent in a couple needs to reduce or leave work due to complex care needs of a child, would they still be eligible for parenting payment if they are the primary caregiver? Um, and does this still require a period of non-payment before eligibility?
Oh, you mean so if a person resigned from their job, which might stop them getting a job seeker payment for a period of time
Mhm.
as a penalty? No, if the reason was if you're applying for care parenting payment because of care needs of a child, there shouldn't be any kind of non-payment period. So we're now at the point of our break. So because this is a 2 hour session, we'd like to give people a bit of a chance to stretch your legs and go to the toilet and get a cup of tea and all that kind of stuff. So we will be back at 3 p.m. We're going to move on to talk about family tax benefit, which is quite a complicated type of payment and does cause many different types of problems. So the first complication is that family tax benefit is divided into two parts, Part A and Part B. So some people just get Part A and some people get both A and B. So the idea behind the family tax benefit payment is that it's to help families with the costs of raising children. So family tax benefit Part A is paid per child. And the total amount a person might get from Family Tax Benefit Part A depends on how many children they have, the ages of those children, because the payment is a bit more for older children compared to younger children. And it's also based on the family's income. The Part B payments is a single payment per family, and it is paid to single parents and some couple families, generally with just one income. So when people talk about family tax benefit or FTB, it's got these two components that are calculated a bit differently. Now, family tax benefit is different to the income support payments we've been talking about. So income support payments are paid fortnightly. So your entitlement is to payment for a fortnight. And that payment is based on your income and assets that you have in that fortnight. Family tax benefit is calculated completely differently. It's calculated as an annual entitlement based on the annual taxable income of the person getting the payment and their partner if they have a partner. So people can choose whether to get one annual payment or to get fortnightly payments. The annual payment of family tax benefit is calculated at the end of the financial year after the person has lodged or the person and their partner have lodged income tax returns or advised Centrelink that they don't have to lodge an income tax return. And Centrelink will then work out based on that annual taxable income how much family tax benefit that family is eligible for and make the annual payment. If people choose to get the family tax benefit payments fortnightly, those fortnightly payments are based on an estimate of what the household income will be in that financial year. And this is where things get messy, because it can be pretty hard for people to estimate what their annual income is going to be, particularly if they work casually, particularly if they're self-employed, particularly if they've got more than one job, particularly if they're partnered for part of the year and not partnered for other parts of the year. And if you're having a busy family life, it's not an easy thing to remember to update your estimate every time there's a change to your income. And we'll talk in the next slide about how all that pans out. So you can claim family tax benefit for the current financial year that we're in and also the previous financial year. So you can apply for that earlier year as well as the year we're in. So it's quite flexible that way, which is good. It can be paid to Australian permanent residents. It can also be paid to New Zealand citizens living in Australia and some temporary visa holders, which is the temporary spouse visa holders and temporary humanitarian visa holders. To get that more than what's called the base rate of family tax benefit Part A, if a person is a single parent, they need to show they've taken reasonable action to get child support for their child or children from the other parent. But it is possible to get an exemption sometimes from having to take that action to get child support. So we'll talk about that in a later slide as well. So the income kind of threshold that you have to be under to get family tax benefit Part A and Part B varies according to how many children you have and how old they are. So we've put in there the links to the pages on the Centrelink website that have the details of the income limits for family tax benefit Part A and for family tax benefit Part B. To get family tax benefit, you have to show that you have a family tax benefit child in your care. And what that means is you have a child who's in your care for at least 35% of the week, of the fortnight. This is different to the parenting payment and other income support payments, so parenting payment can only be paid to one parent, one principal carer, but family tax benefit can be split between separated parents as long as each parent has care for at least 35% of the time. Family tax benefit can be paid if you've got a child under 16 years and from 16 to 19 years if the child is still at high school. The child also has to be an Australian permanent resident or New Zealand citizen living in Australia. And the same child can be the family tax benefit child of more than one person. If we go back to that separated couple, the same child can be the family tax benefit child for each of them. So as I just said, family tax benefit can be shared, so paid to more than one person when a couple is separated and are sharing care of a child. But if a person is a member of a couple, only one member of a couple can get the family tax benefit for that child. Now, for those people getting their family tax benefit payments by fortnightly installments based on their estimate of their income, at the end of the financial year, when tax returns are lodged, if a tax return is required to be lodged, a process called reconciliation or balancing takes place. And so Centrelink will look at the annual taxable income of the person getting the family tax benefit payments and their partner, if they've got a partner. And if their annual taxable income is higher than the estimated income that those fortnightly payments were based on, then that person can end up with a debt to Centrelink. They've got too much family tax benefit payments because their income estimate was too low. If the taxable income is lower than the estimate, then that person will get a top-up payment to take them up to what the correct amount should have been. If the person getting the family tax benefit and their partner, if they have one, if they don't lodge a tax return within 12 months of the end of the financial year, what's called a non-lodger debt will be raised, which means that all the family tax benefit payments in that financial year will be raised as a debt. Centrelink will say you've got to pay us back all the family tax benefit payments we paid you because you haven't lodged your tax return. There are some provisions if the parties have separated in the financial year and the ex-partner has failed to lodge a tax return, that can be accommodated. So the problems we see with family tax benefit, what I mentioned about not continuously updating that income estimate if it changes. So there are some people who would have a pretty good idea of what you're going to earn in the year, and if you're cautious, you'll be a bit conservative and estimate on the low side. But not everyone manages to do that. Something that can come up, remember that I said that family tax benefit can be split between the separated parents, and the split will depend on what percentage of care each of them has. So if one parent has 60% care, the other parent has 40% care, that's how the family tax benefit payment will be split. But sometimes parents are in dispute about, whether it's 40% or 50% or 60%, they won't be in agreement about that. Sometimes we see problems if children are not returned to the parent they usually live with, who gets the family tax benefit payments for them if that goes on for an extended time. Whether that's a problem can depend on whether there's any formal agreements or orders around care of those children after the separation. We mentioned the non-lodger debts. These are very common where people haven't filed tax returns or partners haven't filed tax returns. And as you can imagine, in violent or abusive relationships, this can be used as a bit of a weapon, or a person may have no way of kind of forcing their partner to lodge a tax return to avoid a non-lodger debt. The other issue that comes up commonly is that we'll go on to find out about how child support income affects family tax benefit. And if child support payments are erratic, unpredictable, that can also cause problems because the family tax benefit amount is based on what the person is meant to be getting in child support. And if they're not actually getting it, that can cause a problem for them. And we'll talk about that in a bit more detail later on. So in those situations, if a child leaves a person's care involuntarily, usually when the other parent fails to return them, or maybe some other relative fails to return children, family tax benefit can continue to be paid, often for quite a few months, if the person is taking what's called reasonable steps to have the child returned to their care, and if there's some kind of documented arrangement that the children are meant to be in that person's care, whether it's court orders, parenting plans, written agreement, something like that. And reasonable steps would be considered notifying the police, applying to the family court for what's called a recovery order. But the family tax benefit can't continue to be paid when children are involuntarily out of a person's care if there's no kind of documented care arrangement in place. So we're just going to have a bit of a look at a comparison between parenting payment and family tax benefit, because people are commonly getting this combination of payments, but there are quite a few differences. So as we've discussed, parenting payment can only be paid to one parent, the principal carer, at a time, even if care is shared. And this answers the question we talked about before, that was raised before. If it's hard to choose which parent is a principal carer, an assessment is based on who is disadvantaged most by not receiving a parenting payment. That in itself could be rather difficult to judge, I suppose. And in family tax benefit, we have to have the family tax benefit child in the person's care 35% of the time, and it can be split between separated parents who share care. So we've got a case study here. So Sita left a violent relationship, and her 3 children came with her when she left. She got involved in court proceedings, I think, around the care of the children. And her husband was always demanding more time with the children, even when mediation was going on. He also threatened to stop paying child support unless he had more time with the children. So it was the abuse continued beyond the end of the relationship. So Sita thought she was trying to keep Centrelink up to date with the time the children were spending with her compared to the time the children were spending with him. But it turned out that she, or at least Centrelink said that she hadn't kept them up to date about the changing care arrangements, and that she'd received an overpayment in the amount of $17,000 because Centrelink weren't told of the reduction in the time that the children were spending with her. And therefore her percentage of care started. The case study doesn't tell us how much. I can't remember what the starting percentage was, but it went down over time. And if Centrelink aren't kept up to date, that can lead to a debt. Here's another example, which is focusing on when children are temporarily out of a person's care. So this person ended up in hospital because of being assaulted by her partner. And at that time, when she was in hospital, her mother-in-law was caring for the children. However, after our client was released from hospital, the mother-in-law refused to return the children. And in this situation, this person contacted us because Centrelink said the children were out of your care for several weeks, which meant you weren't entitled to payments during that time. And because there was no documented arrangement in relation to care of the children, it can be hard to argue against that. Here, our client was struggling for various reasons. So she asked her cousin to look after the children for a while. And during that time, the children had an arrangement where they would stay with their father. And so they stay with their father for a week, return to the cousin, and then some weeks later, they return to their mother's care. Now, unfortunately for this client, at a later time, the father basically gave false information to Centrelink saying the children were with him. And as a result of the father telling Centrelink this, Centrelink cut off the family tax benefit payments and issued the mother with a debt. Now, the difficulty here is that when generally in a situation like this, the mother there wasn't a change of care. The mother just temporarily delegated care of the children to someone else on a temporary basis. And people do this all the time when their children attend a childcare centre or a boarding school. They're staying with grandparents or relatives. So if the mother retains overall responsibility and decision making and so on, and the arrangement is temporary, then potentially it's legitimate for the mother to keep on getting the family tax benefit payments for those children. So it does depend whether, if it extended to something in a much longer term, then it might be more likely that the care has changed rather than just temporary delegation to another person. So it's difficult to have hard and fast rules about this, and it's a kind of situation where we would encourage people to get advice from us. Now, in this case, it wasn't a problem because the cousin didn't attempt to claim FTB themselves. This issue about the father making false claims about the children living with him does seem to be a situation that does come up from time to time. What the Centrelink policy says is that they should consult with the mother if they get that kind of information from the father before making any decision about cancelling payments or raising debts. But unfortunately, in this situation with our client, that didn't seem to have happened. But when we raised this with Centrelink at a policy level, they did tell us that both parents need to be consulted before a decision's made. And that's what the Centrelink policy guide says as well. And again, this is a kind of decision where it's very important that the person gets advice and has the opportunity to challenge that decision about who was caring for the children in what time period. So we took action and we were able to arrange for the mother's payment to be reinstated and to lodge an appeal in relation to those payments. Sorry, I've scrolled too far ahead there. I think we've got time for some questions, Bree.
Okay. Can a child have access to the disability payment if the children do not have NDIS plans?
All right. I'm assuming this might relate to a child 16 years and over who might be applying for the disability support pension. And if that is the question, it is not necessary to have an NDIS plan. The eligibility criteria for disability support pension and NDIS are separate. They're not connected.
Okay. Could you please clarify what exemptions there are for refugees? Would a refugee be eligible for any payments other than potentially special benefit if the children are permanent residents? Or would classification as a refugee only waive or alter the qualifying waiting period?
Okay, I'll hope I've understood that question. Basically, refugees, so people who are granted some kind of refugee or humanitarian permanent visa, they do not have the 4-year waiting periods and some of the shorter waiting periods for Centrelink payments. And the spouses and dependent children of people with a refugee visa are also exempt from those waiting periods. So that means they can access whatever payment they might be eligible for without that waiting period.
With family tax benefit, if a tax return is lodged late after the non-lodger debt has been raised, will the debt be wiped if they were eligible?
Yes, the debt, well, whether it be wiped will depend on, it will be reconciled and they may or may not have a debt, depending on whether their income estimate was accurate or high or low. So the debt's likely to be significantly reduced at least and possibly got rid of altogether. But the penalty for not lodging the income tax return on time is that you're not eligible to get any FTB supplements or a top up if your estimate was low. But you will get rid of or reduce the debt once you do lodge the tax return.
Can anything be done if an ex-partner continues to refuse to do their tax returns? Or lodge them, rather.
If the couple are still together, that's very difficult. There is a provision in the Social Security law, we call it Section 24, where a person who is a member of a couple can ask Centrelink to treat them as if they were single, if there is a special reason that makes it appropriate to do that. So if the partner's refusal to file tax returns I suppose, could be interpreted as abuse or coercive control, financial abuse. That may be a ground for Centrelink to treat the person as single for the purpose of Centrelink payments and therefore not have to provide partner details and partner details not affecting their payment. But it could be tricky because if the person is benefiting from that partner's income, Centrelink may well be reluctant to say, we'll treat you as single and not take their income into account for your family tax benefit. So it's really hard if the person stays in a relationship with that person, the person who refuses to lodge tax returns. But come and talk to us. That's a hard situation to deal with.
And at the end, we will have our contact details, just so you know. Okay, so sorry, a lot of the questions are very specific, so I'm just trying to make them a little bit
Find the
more
general
broad.
ones.
Yes.
Okay.
Okay. A mum is on a visitor visa approved for special benefit. She has a newborn that is an Australian citizen. Would the mother be able to get support with childcare rebate?
All right, we'll get on to childcare subsidy. If the mother's on a visitor visa, it would be the child rather than the mother getting the special benefit, technically, because the mothers wouldn't be eligible for any kind of Centrelink payment on a visitor visa. But if the child was Australian resident or citizen, it sounds like the child is getting special benefit. And sorry, what was the last part of that question? I've gone.
Childcare rebate.
Yes, we'll talk about that. But in exceptional circumstances, sometimes non-residents can get childcare subsidy if they're in significant hardship.
So there is another question, but sorry, a lot of the questions are very specific.
Okay.
Just to reiterate, thank you so much for putting questions in the chat, but we do need them to be broad because we can't give out legal advice today.
So relevantly, we're about to talk about childcare subsidy. So that fits in with that recent question. So childcare subsidy is obviously assistance with the costs of childcare. And it is paid for care provided generally to preschool age children and primary school age children, although it is possible to get it for children in the 14 to 18-year age group if they have a disability and need supervision. So for a child who's eligible in terms of their age, there's a criteria for immunisation requirements to be met. The person who is applying for childcare subsidy must have the child in their care for at least 2 nights a fortnight, which is described as 14% care. And they have to have a contract and agreement with the childcare provider so that they're the person liable to pay the fees for the childcare. So childcare subsidy is available to citizens, permanent residents, New Zealanders, people on temporary partner visas and protection visas. And then there is that kind of general, if the person's in significant hardship, even though they're on a temporary visa, as a discretion, they might be able to get childcare subsidy if they can make a case for their level of hardship. So it's definitely worth trying if you have a client in that situation. People applying for childcare subsidy also have to show that they meet what we call the work, study or training test. And the phrase recognised activities is also used. So they have to show they're doing recognised activities or they have an exemption from doing recognised activities. A change came in on the 1st of July 2023 so that First Nations children can get 36 hours of childcare subsidy without having to do those recognised, without the parent having to do those recognised activities. So recognised activities are things like paid work, self-employment, actively looking for work, actively setting up a business, up to 16 hours of voluntary work. It could be unpaid work experience or studying. So quite a lot of things can fall into this basket of recognised activities to be able to get subsidised childcare. On this slide, you can see for, depending on how many hours you do your activity, depends on how many hours of subsidised care per fortnight a person might be entitled to. So you can see there, if a person's activities are done for less than 8 hours in a fortnight, then depending on the family income, they might get no hours of subsidised childcare or 24 hours of subsidised childcare. And then you'll see as the hours of activities per fortnight goes up, then the number of hours of subsidised childcare a person might be able to get the childcare subsidy for also will go up. Now, in terms of those exemptions from which would mean you could still get the subsidy even though you're not doing the work, the looking for work, the setting up a business, the studying. So those exemptions can apply if the parent or carer has a disability, if they're temporarily outside of Australia, if they're in prison or in a psychiatric facility, if the parent or carer is receiving carer payment, or if they're caring and the only reason they can't get the carer payment is because they don't pass the income or assets test. Grandparent carers don't need to do activities to get the childcare subsidy. And people who have an exemption from their mutual obligations for some of those exemptions will also be exempt from recognised activities. So mutual obligation exemptions that don't include the child under 6 or large family, or the child-related exemptions. If there are other exemptions, which are things like a major personal crisis, homelessness, domestic violence, natural disaster, jury duty, that kind of thing. So generally, the childcare subsidy is paid directly to the childcare provider, which will reduce the fees paid by the parent or parents or carers. The amount of the subsidy depends on, like family tax benefit, an estimate of the family income for that financial year, and then the hours of the recognised activity that the person applying for the subsidy is doing, and also the number of children in care and their age. So it's quite a complicated calculation. So at the end of a financial year, like with family tax benefit, there'll be a reconciliation using what the actual taxable income was. And again, like family tax benefit, if a person's income is higher than their estimate, they could get a debt. And if lower than the estimate, it could be a refund. So in a two-parent family, one of them needs to apply for the childcare subsidy, and usually it will be the person who's kind of made the agreement with the childcare provider. It's important to lodge a claim for childcare subsidy pretty early on after enrolling a child in childcare, because childcare subsidy can only be backdated a maximum of 28 days before the claim was made. So if you don't claim quickly after you enroll your child, you might miss out on subsidy from some of the days your child's in care. The income tests are very generous for childcare subsidy. So you see for people whose family income is less than that 83,280, they get a 90% subsidy. And then when the family income goes right up to 533,000, there's some degree of subsidy, and it's a sliding scale as the income moves higher from that 83 to the 533. So relatively generous compared to any other kind of Centrelink payments. We talked about the fact that it can't be backdated more than 28 days before the date of claim, even if the child started the childcare centre before that date or started with a childcare provider. In most cases, the payments go to the provider. There could be a short period where the payments go to the parent if the child's already started childcare when the application's made, and then after that to the childcare provider. So there is something called additional childcare subsidy, which gives extra subsidy for up to 100 hours a fortnight. And this is aimed at families and children who suffer some disadvantage. So there are different categories. One is where children are at risk of serious abuse or neglect, or where grandparents on Centrelink payments themselves are the principal carers of their grandchildren. Families who for some reason are in temporary financial hardship, and also for some people where they're moving from being usually on the job seeker payment into paid work, that transition. And for additional childcare subsidy, don't do that reconciliation process at the end of the financial year that happens for family tax benefit and the ordinary childcare subsidy. For the children at risk of serious abuse or neglect, that is linked to decisions being made by the child protection authorities under the child protection laws. So generally in these situations, the childcare provider has to provide a certificate that they think a child in their care is at risk of abuse or neglect. And if that risk continues for more than 12 weeks, then there's another step where the childcare provider can apply to Centrelink for a determination that the child is at risk of abuse or neglect over a longer period of time. In terms of the temporary financial hardship, that can be if there's been a death of a partner or a child, loss of employment, business failure, natural disaster, severe damage to a home, domestic violence, that kind of thing. For grandparent carers, they would qualify if they're providing at least 65% of daily care of their grandchildren and they're getting an income support payment themselves. So some of the problems we see with childcare subsidy is that recognised activities, work, study or training. We find it comes up particularly with study when people's hours of study drop and they don't tell Centrelink, or they withdraw from the course, don't tell Centrelink, that kind of thing. Income estimates, the same kind of problems as with family tax benefit. And obviously parents can be left paying full fees, which are, as we know, very high if for some reason their claim is rejected when they apply or if it's cancelled for some reason. And the usual member of a couple issues apply as to whether it's a single person's income that goes to the income test or a couple's income that goes to the income test. Now, I want to talk a bit about family tax benefit and childcare subsidy debts. So debts can arise if it turns out the person was not eligible for the payment. This can happen particularly if the child has left their care. for, the many reasons that could happen, or the income is changed, or then turns out they, are not in Australia or not residents, or, they just don't meet one of the criteria. We've talked about the reconciliation debts, where at the end of the financial year, when the taxable income is known, this balancing or reconciliation happens. And if they gave an underestimate of income that their fortnightly payments were based on, they'll end up with a debt. And we've also talked about the non-lodger debts, failure to lodge a tax return by the end of the next financial year. With the non-lodger debts, so for example, for the 23-24 financial year, you need to get your tax return in by the end of the following financial year. So in this case, it would be 30 June 2025. As we've said, if you don't get that tax return in and your partner doesn't, then all the family tax benefit you got in that year becomes a debt to be repaid. And then, as we mentioned before in answer to that question, if you do lodge the tax return but late, you miss out on any top-ups or supplements that you might have otherwise got. Now, for people who have non-lodger debts, outstanding non-lodger debts, and haven't lodged their tax returns, and there's that 75-day kind of grace period to get your tax returns in. If that doesn't happen, then fortnightly family tax benefit payments may be stopped, although you would still be eligible for the annual payment at the end of the financial year if tax returns are put in, so that the reconciliation can be done. For couples who separate, and it's the partner, the ex-partner, who hasn't lodged the tax returns. So if family tax benefit payments have been stopped because of the partner's failure to lodge a tax return, if the couple separates after that, then the fortnightly tax benefit payments can start again. Although if they reconcile and they still hasn't lodged the tax returns, the fortnightly FTB payments will stop. And as we discussed before, once the tax returns are lodged, there will be a reconciliation, and it's possible the debt will reduce or disappear. The real problem can come if over 3 or more financial years, tax returns are not lodged and non-lodger debts are raised. A person will lose their entitlement to family tax benefit entirely. So it leads to quite significant problems. Next topic is child support and Centrelink. So we've talked quite a bit about percentage of care, and when parents are separated, how the care of the children is divided between them. So commonly it will be the child support people who make a decision about what percentage of care each parent has, and Centrelink uses the same percentage of care figures as the child support agency people have decided. So Centrelink will only change those child support percentage of care figures if there's been some kind of change in arrangements since the child support people made that decision. As we've discussed, Centrelink should consult with all the, or both or all the parents or carers to verify any reported changes in care. If there's a dispute, if the parents are giving different stories about what time the children spend with each of them, it may be necessary to provide evidence to Centrelink, which could be from the school, from a general practitioner, from a social worker, less persuasively from friends and relatives, about how much time the children spend with each parent, to try and persuade Centrelink if you think the percentage of care is wrong. The other way that child support affects family tax benefit payments is that, as we said earlier, it's a requirement for people getting family tax benefit Part A to take reasonable action to get child support if they're going to be paid more than the base rate of family tax benefit. So the base rate of family tax benefit at the moment is $71.26 a fortnight, whereas the maximum rate for children 0 to 12 is $222 a fortnight and $288 for children aged 13 to 19. So that's a significant difference in payment if people haven't been judged by Centrelink to have taken reasonable maintenance action, which means applying to child support for an assessment or providing a child support agreement, or even if the parent is overseas, applying for child maintenance in that other country. However, it is possible to get an exemption from having to take reasonable maintenance action, particularly if there's a fear of violence, but also if the identity and whereabouts of the other parent's unknown or other exceptional circumstances. When a parent is entitled to receive child support, that can affect the amount of the family tax benefit Part A that they get. So there you can get a certain amount of child support income without it affecting your family tax benefit, which is known as the maintenance income free area. I can't give you any figure for the maintenance income free area because it depends on how many children it relates to. But where problems can come is if a person is assessed to be getting a certain amount of child support, but it's not actually being paid. And therefore the person is getting less family tax benefit than they really need. So there is a way of changing how child support is assessed in relation to family tax benefit. And that's something that people can be referred to us to get advice about, because there are some pros and cons in doing that. But it may help some people that their rate of family tax benefit is assessed on the child support they're actually getting in the hand, as opposed to the amount it's been assessed they should be receiving. So that's definitely something that people can be referred to us for advice, and it usually needs the involvement of a Centrelink social worker to be able to make that happen. I was just going to briefly mention youth allowance for older children. So once children are over 16, if they're looking for work or doing an apprenticeship, if they need to move away from home to study, and they're studying full time, they may be able to get youth allowance. Once a child starts getting youth allowance, though, the parent cannot get family tax benefit for them anymore. So it can't be a situation where the parent's getting family tax benefit and the child's getting youth allowance. It has to be one or the other. Generally, to get youth allowance, you have to be studying full time or looking for work, but there are some exceptions to that, which are listed there: illness, disability, pregnancy, being homeless. But youth allowance is subject to parental income tests unless that young person is categorized as being independent. That is a whole other session, and we have one of our sessions based on payments for students where we go into that in a lot of detail, in what circumstances a young person will be considered to be independent from their parents, even though they're under 22, because for Centrelink purposes, children are considered dependent until they turn 22. So although there's a parental income test, there's no parental asset test. But there are income tests for the young person and their partner. Ab study is another payment that young people with children might be able to get. Ab study is a payment that can be paid to people of all ages if they're Aboriginal and Torres Strait Islander and are studying. But there are particular types of ab study payments that can be paid to high school students and can cover a range of costs such as travel, school fees, boarding school fees, living costs, books, etc. But ab study is also means tested on parents' income. All right, we've gone through all the payments I'm going to talk about, and we're very close to the end of our session now. So we've talked about a whole lot of different payments and problems that come up with those payments. The kinds of decisions that Centrelink may make that affect people can be rejecting a claim for a payment, suspending or cancelling a payment, making a decision that someone's a member of a couple, making a decision that a person has a certain percentage of care of a child, making a decision about whether a person is a principal carer. So any of these decisions by Centrelink can be appealed. The kind of technical word is that those decisions can be reviewed. However, we do caution not to rush to appeal every single decision. We ask that people are more cautious about decisions relating to debts and get advice before starting the appeal process for a debt, because it's certainly possible, and we see it happen, that when Centrelink looks more closely at that debt in the review process, they decide that the debt should actually be bigger than it is. So people can end up in a worse position. So definitely worth getting some advice before appealing for a debt. For other types of decisions, there's not generally any risk in starting that review process. There are, however, some time limits to be aware of. So for income support payments, so parenting payment, carer payment, special benefit, job seeker payment, the ones we've talked about today, if your claim for a payment's been rejected or your payment's been cancelled or suspended, or Centrelink have made a decision about your couple status or care of your children, you generally need to start the review process within 13 weeks of being notified of that decision to be able to get back pay if it turns out that the Centrelink decision was wrong and it gets changed. For family assistance, which is the family tax benefit, you generally have a year to ask for a decision to be reviewed. But paid parental leave, you only have 28 days. Got to get in very quickly. And for debts, no time limit. So there's time to get advice about whether it's advisable to try and appeal against a debt. You'll see there are different appeal levels. So the appeal process against a Centrelink decision starts with an internal review by a person at Centrelink called an authorised review officer. If you're not happy with that decision, you have a right for a further review by an independent tribunal, the Administrative Review Tribunal, and this tribunal replaced the Administrative Appeals Tribunal in October last year. If you're not happy with the decision of the tribunal, and you can see there are time limits there for applying to the tribunal, you have 28 days to ask the tribunal to do a second review. All those reviews are free, so it's quite an accessible system. If you decide to appeal from the tribunal to the federal court, that is not free, and we don't suggest anyone does that without getting advice first. Very high risk. All right. I think we might only have time for one or two questions. Maybe not even that.
Yeah. Maybe.
Too many to.
Oh, okay. So I have my colleague has said that I should let you know, because we need to finish up, that we do have videos on our website, training videos on a range of different subjects and fact sheets if you need more information about any of the topics. And our contact details are also at the end. Unfortunately, we do need to finish
Move on.
up.
Okay,
Sorry.
let's do that.
Okay, so some clients may have difficulty accessing Centrelink due to a range of issues. So we've compiled some resources on the following 3 slides so that you can support them. The slides should have been sent to you, but I will also send them out again via email when I notify everybody about the recording of this webinar, which will also be on our website, should be next week sometime. We also have information on these slides about contacting Centrelink social workers. Next slide. Yep, so there's those details there. If you have a problem with Centrelink in New South Wales and you wish to speak to someone at Welfare Rights Centre, our client intake line is open every Monday and Wednesday from 9:30 a.m. till 12:30 p.m. Or you can contact us online via our web form or email. The details are all here. So please follow us on Facebook, Instagram, LinkedIn, and we have a new account on Blue Sky for regular updates and educational information. We have online resources, including recordings of our webinars that I have mentioned, and other educational videos and fact sheets, all available on our website. So we would appreciate it if you could please take 5 minutes to complete our evaluation survey. An email should have gone out to you this afternoon with this link. Your feedback helps us to improve and also to secure funding so that we can continue to offer these free webinars. So we hope that you enjoyed our session today, and we look forward to seeing you at future events. Thank you to Extra for helping us fund our community worker training. And thank you, Natalie.
And thank you, Bree. And goodbye, everyone.